Sharp versus Dawes in our previous class. So I think we left at the bit where we were looking at the essentials of a valid meeting. So we talked about we said that economic security. Okay, just a minute. So sorry about that. So we said the essentials of a valid meeting, that the meeting should actually be convened by the proper authority, So number two, we said there should actually be what we call a notice. Number three, we said that there should actually be what we call a quorum. Number four, there should be a proper person as the chair, and we went into details with regard to these particular essentials. And the last one, which we are just to look at, minutes should actually be maintained. Minutes to be maintained. So I think we looked at in deeper details with regard to these particular essentials. So I do not actually want to repeat again. So I think you can be able to remember what we looked at. So the last thing that is actually very important, we need to look at it, is actually minutes should actually be maintained at the company meeting. So sometimes they could ask, what are the contents of these particular minutes? So if they ask for such, just know that there are normal minutes you've learned about in English, in your English study, for example, in your English study, that when you have minutes, what you start with is basically the place and time, or basically the place or where the meeting was actually held, and also the time and actually date. Then of course you go to the persons who are actually present. So members, maybe if it is a general meeting, the members who are actually present at that particular meeting. Those who are absent with maybe apologies. Then on those ones present, you clearly indicate who was the chairman, who was, for example, the secretary in such a case. Then the agendas actively discussed in the meeting will actually also be listed in the minutes. Then at the end of it all, the minutes will actually be signed by the chairman of the meeting and also the secretary of the meeting. So that is basically what you'll likely be able to get in the minutes of company meetings. Just the normal format of minutes, that these minutes will clearly indicate the date and time and the place where the meeting was actually held. Those who are actually present, those who are absent with apologies, they'll clearly indicate who was the chairman among those ones who are actually present. who was the secretary among those ones who are actually present. Then, of course, you go to the active agendas, basically the actively discussed agendas at that particular meeting. Then at the end of it all, we are saying that any minutes, basically you'll see they have been signed by the secretary, and of course, also they have been signed by the chairman of the meeting. So that's basically what you need to be able to know about with regard to the minutes of the meeting. So we can look at the types of meetings that we can actually have in a company, the types of meetings we can actually be able to have in a company. So we can have what we call an AGM, or in full, an annual general meeting. Then we can just have a normal meeting, or basically just a general meeting of the company, general meeting of the company. Number 3, we can have what we call a class meeting, a class meeting. So these are the types of meetings we can have in a company. Number 4, we can have what we call a directors meeting, or a board of directors meeting, directors meeting. Number 5, we can have, for example, a creditors meeting in a company, a creditors meeting in a company. These are some of the types of meetings that you are likely to have, or probably can actually be held in a company. So the most key ones to be able to understand, especially there, this AGM, general meeting, and also a class meeting. So when you talk about an AGM or an annual general meeting, it is a meeting that is normally held once each and every year by the company. So it is a meeting as per the requirements of the statute to be held once each and every year by the company. So as per the Companies Act, or as per the statute laws governing regulations of operations of companies, it is a requirement for a company to hold this particular meeting each and every year. So it is normally a meeting that is normally held once each and every year by the company. Another thing to know about the AGM, it is mostly held, basically it is mostly held within a period of 6 months after the end of the financial year. So what are we saying? We are saying that this is a meeting that is normally held once each and every year by the company as per the requirements of the statute, or as per the requirements of the Companies Act. So if you look at the Companies Act, basically it requires that this particular meeting is mandatory to be held within a year, or in each and every year in the existence of the company. So we are saying that most companies prefer to hold it within a period of 6 months after the end of the financial year. So for example, if the financial year actually ends maybe in June, most probably this meeting will be held between July and actually up to the end of the year, which is actually December. If basically the end of the financial year of the company is actually December, probably this meeting will likely be held in January up to around June the coming year. So what are normally the active agendas? So this one I think we tackled in a particular question that was asked by one of our friends here, that what are the active agendas that are normally discussed at an annual general meeting? So what are the active agendas that are normally discussed at an annual general meeting? At the AGM, we said that at the AGM, so the agendas at an AGM, the agendas at an AGM. So number 1 is approval of the proposed dividends of the company, So there'll be that particular approval of the proposed dividends of the company. There'll be the appointments, and removal of the company auditors. Then also there'll be the appointments and removal of the company directors, So we're saying approval of the proposed dividends of the company, appointment and removal of the company auditors, appointment and removal of the company directors. Then number 4, approval of the annual accounts of the company, approval of the annual accounts or books of accounts, approval of the annual accounts or books of accounts of the company. Then maybe the last one, any other matter as per the notice convening the annual general meeting. So they can discuss any other matter so long as it was actually basically among those particular agendas that were listed in the notice sent out by the company, So these are the agendas that will take place at an annual general meeting of the company, that the dividends of the company will simply be proposed by the directors of the company. That's why we are saying mostly it is normally held within a period of 6 months after the end of the financial year, because after the end of the financial year, the directors have actually been able to prepare the books of accounts, and therefore they can be able to tell which amount of dividends can be paid to the members of the company. So they'll propose from what they have actually been able to realize as maybe profits of the company. So after that, basically, they'll present it to the members of the company, the key stakeholders, who are actually basically the owners of the company, at an AGM. That's where basically now these particular dividends will actually be approved. So after that, the dividends can be paid to the members of the company. So dividends will most obviously be paid after an AGM has actually been held. So after the approval has actually happened at the annual general meeting. So appointment and removal of the company auditors. So the auditor will basically serve up to the end of the financial year and basically audit the books of accounts and present them to the members of the company. So who are the key stakeholders? So he safeguards the interest of these persons we are calling members of the company. So if the members deem fit that this auditor can actually continue to maybe carry on with these duties, or they can actually decide basically to appoint another person and remove this particular auditor. So it will actually only happen at the annual general meeting. So members are the key persons who will actually who have the rightful mandate to appoint an auditor in a company. So you'll discover this when we'll be looking at the topic of auditors, which we are almost going to cover. Maybe after 2 or 3 topics, we'll basically be looking at auditors in a company. You'll be able to understand who is an auditor of the company, and basically how does the appointment of an auditor actually happen in a company. So you'll see the key persons who are supposed to appoint an auditor in a company. The mandate basically normally lies squarely with the members of the company. So maybe due to certain circumstances, maybe it can be appointed in an acting capacity, maybe by the directors of the company. Then appointment and removal of directors. So the members also have a key say. So they are the persons who have the rightful mandate to appoint the directors of the company. And normally it actually happens at the AGM. Maybe under exceptional circumstances or under special circumstances, the board of directors can actually appoint a director in an acting capacity until the next AGM. Because you can't wait for the AGM yet, there's a vacancy in the board of directors, or basically a director who's supposed to be appointed to provide expertise to the board. So they'll basically appoint someone in an acting capacity until the next AGM. So they can't wait for the AGM. So it might take a long period of time, because this is only a meeting that happens once each and every year. So therefore, since you are saying this can only happen at the AGM, they won't wait for the AGM. They might actually decide to appoint a director in an acting capacity. But generally, the persons who have the rightful mandate to appoint directors in a company are normally the members of the company, or basically the owners of the company or shareholders at an annual general meeting. Approval of the annual accounts of the companies. Why have we said that this meeting happens at the end of the financial year? The books of accounts have been prepared, they've been audited by the auditor, and therefore now the members, who are the key stakeholders, who are the owners of the company, are the ones to approve these particular books of accounts. So it will basically happen at the AGM. That's why it happens 6 months after the end of the financial year. Any other matter they deem fit can be discussed at this particular AGM, and of course it has actually clearly been indicated in the notice convening the AGM, can also be discussed at the annual general meeting. So any other matter that is actually of importance to the company that is supposed to be discussed at the AGM can actually basically happen at the annual general meeting. But of course, these are the key agendas that will happen at an annual general meeting. So they could ask such kind of a question, and we saw it last time, so it can be tested in the exams. What are the agendas at an annual general meeting in a company, an annual general meeting in a company? So the proper notice to convene this particular meeting is normally actually 21 days. So basically there should be at least a notice of 21 days as per the requirements of the Companies Act or as per the requirements of the statute. So if you are issuing the notice today, it basically means that the notice basically should actually be maybe within 21 days. So after maybe 21 days, that's when the meeting can actually be held, So that is what we mean by an annual general meeting. So we are saying we have another meeting. It is known as a general meeting. So if we have an AGM that happens only once each and every year, certain matters might not actually wait for the AGM. So it simply means that there might be other meetings in a company. So these other meetings in a company which are not actually an AGM basically will be termed as just being general meetings of the company. So they are just general meetings of the company. So pressing matters can't wait for the AGM to happen. So the company can actually be able to convene what we call a general meeting and simply discuss and actually resolve these particular matters. So any other meeting in a company which is not an AGM, or basically that is normally held in a company which is not actually an annual general meeting by the members of the company, it will be termed as being a general meeting of the company. It will be termed as being a general meeting of the company. So it is any other meeting in a company other than the AGM convened for the purpose of discussing matters of urgency in the company, which can't wait for the AGM. So it will be termed as being a general meeting. So this one can be convened anytime, can actually be convened anytime, so long as there's something that is actually very important to be held or basically discussed in the company. What the board of directors can actually be able to do is just to convene this general meeting and of course discuss the matters that are actually at hand in that regard. So any other item which is not among these ones can actually be discussed at the general meeting. So maybe you can say some of the matters could actually include, for example, change of articles. It can be discussed at the AGM. Change of the name of the company, it can be discussed at the general meeting of the company. So change of articles at the general meeting of the company can basically be discussed. Reduction of share capital can actually be discussed at the general meeting of the company. So long as it is any other matter concerning the company, which is not among these ones, can basically be resolved at the general meeting of the company. You can talk about share capital reduction, change of name, change of articles, change of the memorandum of association. We can be able to talk about petitioning, or basically seeking for a petition to basically recommend for the liquidation of the company by the members. It can happen at a general meeting of the company. So anything that is actually not among these ones can actually be discussed at the general meeting of the company. Any other matter or any other agenda that is of importance to the company can be discussed at the general meeting of the company, so long as it's actually not among these key ones, which must actually basically be discussed or actually approved at an AGM. That is what we mean by a general meeting. So it is any other meeting in a company which is not actually an AGM, to discuss any matter of urgency or any matter of importance which is urgent in the company. So it will be discussed at the general meeting, which can be called anytime during the year. Anytime during the year, it can actually basically be called by the board of directors for the members to be able to resolve matters concerning the company. Then we have a class meeting. So a class meeting, as I had explained previously, so it is simply a meeting that is actually held by members of a class of shares. So, and I emphasized on what is actually a class of shares. I explained it severally in our last class. So a class of shares is basically whereby we say shares of the same class if they have what we call similar rights. And of course, if you remember the topic of shares, we looked at different classes of shares. We said you can have ordinary shares, you can have preference shares. It simply means that the holders of ordinary shares enjoy what we call similar rights in the company. That basically they can decide as to how much they are going to get as dividends in the company. So at the AGM, they can decide how much they are going to be paid as dividends. So they are the persons who carry the main business risk, or basically carry the main risk for the business, So they are the equity holders. So they are entitled to basically, let's say, for example, all the residues of the company in case the company is actually liquidated. So when you talk about members being of a class known as ordinary shares, we mean they have what we call similar rights. So a class of shares is simply where we are talking about, a class of shares is simply where we are talking about those shares having what we call similar rights. So shares that have similar rights will be of the same class. If it is preference shares, the holders of these particular shares will have what we call similar rights. So when we talk about a class meeting, it simply means that it is a meeting, let's say, for example, that has been held by all the ordinary shareholders of the company. So they have not actually involved the other shareholders in other classes, like maybe, let's say, for example, preference shares. So if those members who hold preference shares in a company hold a meeting, it will be termed as being a class meeting. So mostly they might hold a class meeting, and maybe their key agenda could actually basically be to vary the rights of the members of that class of shares, because you are seeing they enjoy similar rights. So sometimes the rights can actually be varied by the company, and the company can't just vary the rights without having consulted these members of this class of shares. Or in short, they have to ensure that the company has to ensure that the members of that class of shares have been able to approve of the variation, have actually been able to approve of the variation. So when you talk about variation of class rights, so it is important also you understand it, because you are saying it can happen at a class meeting. It can happen at a class meeting. It can happen at a class meeting. Variation of class rights. Variation of class rights. It can happen at a class meeting. It can happen at a class meeting. So variation of class rights. Variation of class rights. So what we mean by this, so as we've said, that members of the same class of shares will enjoy what we call similar rights. So if it is preference shares, they are saying it is 6% preference shares. It simply means that these members of class of shares can enjoy dividends at a rate of 6%. So if the company is to vary these rights, let's say, for example, if the company wants to change and vary, let's say, for example, from 6% to 5%, they cannot just do it without having to consult the members of this class of shares. So there'll be a procedure to be followed to vary the class rights, from basically getting dividends at 6% to 5%. So that's basically an example of what you're talking about, variation of class rights. So when you're talking about, for example, the voting rights of ordinary shareholders in the company, if these rights are to be varied by the company, it can only be approved by members of that class of shares. So they must actually be able to approve of it before the company can proceed to vary the rights of that class of shares. So in this case, if the company is to vary the rights or the class rights of a class of shares, or the rights of a class of shares, it simply means that the members of that class of shares will convene a class meeting. So they will convene a class meeting, and at that particular class meeting, they'll be able to pass what we call a special resolution. They'll pass a special resolution. What is a special resolution? A resolution that is basically approved by a supermajority, or at least 75% of the members who are supposed to attend and actually vote at such kind of a meeting. So those members who have a voting rights of 75% who are supposed to attend and actually vote at such kind of a meeting. So we've said this, the company cannot just vary the class rights. It has to consult the members of that class of shares. Therefore, a class rights variation procedure has to be followed. So once that one actually happens, they consult them. What will happen? The members of that class of shares will convene a meeting known as a class meeting. At the class meeting, they'll pass a special resolution to approve the variation, So it means that that variation can only be approved or can actually sail through if at least 75%, those who have the voting rights in that particular class of shares, have been able to approve. If it is approved by 55%, this is not quite enough to approve the variation. The variation won't sail through. The company won't proceed and actually carry the class rights variation. So they won't basically change the dividends from 6% to 5% because it has not actually been approved by the required percentage of members who are supposed to vote at such kind of a meeting. It has been approved by 55%. It is not the super majority required because you are saying it requires a special resolution. 55% is still majority, but of course it is not enough majority to approve such kind of a resolution. So the company won't proceed. But if it is actually approved by 75%, approved by a special resolution, it simply means that that will actually be quite okay, and the company can actually be able to proceed and vary the dividends from 6% up to 5%. So that is what will actually happen in case the variation is to happen. The members of that class of shares will convene a class meeting. At a class meeting, a special resolution will actually be passed to approve the variation of class rights. Once that one has actually happened, the resolution basically will be provided, or basically will be filed with the company. Then once the company gets that particular approval of members in that particular class of shares, they can proceed and do the variation of the class rights. So that is what will actually happen. So however, those basically who are actually minority members in that particular class of shares, so at least 15% can object. You can see 75% have approved, but of course you are remaining with a minority of 25%. So out of this 25%, at least 15% who are actually minority can petition the court and actually stop the variation. What you mean by petitioning, they'll simply present to the court the reason as to why they feel that even though the majority members in that class of shares have approved, as the minority, this is basically what we have to propose, or basically we have to give the court to object to the variation. So you are saying the minority still have a window. Because 75% have approved, you are remaining with 25% who are actually minority. They still have a window to basically stop the variation. How do they stop the variation? They petition the court. When you talk about petitioning the court, they provide evidence to the court as to why they are objecting to the variation of dividends from 6% to 5%. So basically, the court will look at that particular petition. Why are they objecting to that variation of dividends from 6% to 5%? So if the court basically sees the petition to basically be valid, the court will basically give out an order to stop the company from varying the class rights. So once basically they have petitioned and they have won in a court of law, the court can give out an order to stop the variation from 6% to 5%. So maybe the majority in that class of shares have colluded to basically now vary the rights of the members in that particular class of shares, but the minority still have a window. What is the window? The window is they can be able to petition the court and of course object to the variation. If the court deems fit, they can actually basically be able to give out an order to stop the variation of class rights. Once that one actually happens, the company won't proceed to do the class rights variation. So hope you've gotten it very clearly, because they could test in the exam, what is the procedure of variation of class rights? The teacher has said that before the company varies the rights of a class of shares, they have to consult the members in that class of shares. The members in that class of shares will convene a class meeting. At the class meeting, they'll pass a special resolution. What is a special resolution? A resolution that must actually be approved by at least holders of voting rights of 75% in that class of shares. Once that one has actually happened, the resolution will basically be presented to the company, and the company can actually be able to proceed and do the variation of class rights in that class of shares. So the teacher is saying, for example, to vary the dividends from 6% to 5%, the company will proceed. However, the minority in that class of shares, still have a window to object to the variation. How do they do it? This is how they'll do it. They'll petition the court. When you talk about petitioning the court, they provide evidence to the court as to why they don't want the rights to be varied. If these reasons they give the court are valid, the court basically will object, or basically will give out an order the company not to proceed with the variation of class rights. If that one actually happens, it simply means that the minority in that class of shares have won, and therefore the court won't reduce the dividends from 6% to 5%. So that's what we mean by variation of class class rights. You need to get it very clearly. So it might actually be tested. So directors meetings, when we talk about directors meetings, this is simply basically a meeting of the board of directors of the company or the directors of the company. So they can meet regularly to discuss matters concerning the management of the company. So they have been put there, they have been given the mandate, they have been put there, or they have been given the mandates by the shareholders to manage the company on behalf of the owners or the shareholders of the company. So basically they might meet frequently to discuss the matters concerning the company in terms of basically ensuring the company is maybe successful, operating successfully, it is able to compete with the other players, maybe in the same industry. So it basically just discuss matters concerning the management of the company. So that's what we mean by a directors meeting. So not much you need to be able to know deeper about directors meeting. Most probably, maybe the question they could test is basically what I've seen. It has been tested. They have asked, what is the contents of minutes of a board of directors meeting? So as I've told you, minutes are just minutes. So nothing unique about our meetings minutes. Even in a directors meeting, they'll just basically indicate the meeting was held in the boardroom of the company on this particular date at this particular time. The directors present were these ones. Those absent with apologies were these ones. The active agendas discussed in the board of directors meeting were these ones. There is nothing unique about a meeting's minutes. Basically, minutes are just the same, whichever kind of meeting. So that format you just learned in English will basically will be applied everywhere, even in basically like a CHAMA meeting. Nothing unique. So it will just be the same. The meeting of the CHAMA was held, even if it is a wedding meeting. The meeting of the wedding was actually preparing for the wedding, or the wedding committee was actually held at this particular building, room number this, on this particular date. Those present were these ones, these absent apologies were these ones. Agendas, number one, it was actually contributions. So you discuss about contributions, you discuss about how basically you'll be able to maybe get cars for the wedding. You discuss about where you'll basically get the gown, so the suits. So such kind of matters will basically be. So minutes are just minutes. Don't think that board of directors minutes are very unique. So if they ask for the contents of a board of directors meeting minutes, just indicate those ones. So where it was held, place and time, those present, those absent with apologies, active agendas. And of course, it will be signed by the chairman and the secretary of the meeting. Creditors meeting, it is a meeting of the creditors of the company. So most probably, maybe they could meet to discuss matters concerning them as creditors, so whether they are being treated fairly by the company, or maybe basically they are meeting to propose that the company be liquidated, or they are going to basically meet and actually appoint a liquidator for the company, So we can look at resolutions that are normally passed in a company meeting. As I've told you, there are two major resolutions. So we can have an ordinary and a special resolution, an ordinary and a special resolution. When you talk about resolution, these are simply decisions that are normally undertaken or basically approved at a company meeting. So they are simply basically decisions that are normally approved at a company meeting. So when you talk about an ordinary resolution, it is simply a resolution that actually requires what we call a simple majority to approve. A simple majority simply means so long as it is 50% plus, 50% plus is quite enough to approve such kind of a resolution. So an ordinary resolution is one that will be approved by a simple majority. A simple majority, we mean 50% plus. A special resolution is one that the teacher has talked about, for example, under that case of class meeting, that requires a supermajority of basically at least 75% of the voting rights, or members who hold the voting rights of at least 75% to be able to approve such kind of, it is one that requires at least members who hold voting rights of 75%, of at least 75% to approve. So it is one that requires at least members who hold voting rights of 75% to be able to approve. When you talk about an ordinary resolution, so some of the matters that just require an ordinary resolution, so most of them are the ones we've talked about under the AGM. For example, approval of the annual books of accounts, so just requires a simple majority, so nothing so much special about it. When you talk about, for example, in this case, appointment of directors and reappointment of directors, it just requires a simple majority. Appointment of auditors just requires a simple majority, so it doesn't require a special resolution. Approval of the annual dividends just requires a simple majority. It doesn't require a special resolution. So those ones that require special resolution include, for example, change of name. So change of name requires a special resolution. Share capital reduction, share capital reduction, share capital reduction. We can be able to talk about change of articles of association, change of articles of association, change of memorandum of association, change of memorandum of association, change of memorandum of association. We can talk about mergers. You can talk about acquisitions, matters to do with acquisitions of the company, acquisitions of the company, winding up of the company. You can talk about winding up of the company or liquidation, winding up or liquidation, winding up or liquidation, winding up or liquidation, winding up or liquidation. So these are some of the matters that require what we call a special resolution. So change of name will require at least 75% of the members to approve. Share capital reduction, at least 75% of the members should actually be able to approve. Change of articles of association. So when I mention articles at this particular point, you should actually be understanding what is an articles of association. It is simply the constitution of the company, or basically a document containing the rules that actually govern the internal affairs of the company. It is known as the articles of association. Memorandum, it talks more about the company to the outside world. So it basically has what we call the name clause, objective clause, and all those other clauses, like, for example, share capital clause. Mergers, if the company is to merge with another company, it must actually be approved by at least 75% of the members of the company. Acquisitions, if the company is to be acquired, or basically be acquired or purchased by another company, so it must actually be approved by the majority of, supermajority of the members. If the company is to be liquidated or be wound up, so at least it should actually be approved by the supermajority of the members of the company. If the life of the company is to come to an end and it is going to be liquidated by the members of the company, so at least 75% who hold such kind of voting rights should actually be able to approve such kind of a resolution, such kind of a resolution, such kind of a resolution, such kind of a resolution. So that is the end of this topic. That is the end of this topic. I want us to start the next topic, which is directors. Yes, you have a question.
When you talk about 75% of the majority,
I'm not getting you clearly. I don't know. I'm not getting you clearly.
Unanipata sasa?
Yes, now I can get you. Speak audibly.
Okay. So when you talk about 75% of the majority,
yes,
do you mean they hold 75, like their vote, the number of shares they own, the number of people in that meeting should be like 75%?
They have a voting right. What I mean, they have a voting rights of 75%.
Per person.
They have a voting rights of, not per person, cumulatively.
Okay.
Cumulatively, they have voting rights of 75%. Not that one person holds 75% of the, because you as a person, you can't hold 75% of the shares of the company. At least cumulatively, you'll find that, you know, you could be like, let's say, for example, a million members of the company, So this one has 10 shares. This one has 20 shares. This one has maybe 60 shares. So cumulatively, if you basically combine your voting rights, it simply means that you are controlling 750,000 out of a million. For example, if the company has just one share, which is actually at 1 shilling, constituting to basically a total share capital of a million. So it simply means that those who are controlling at least 75%, 750,000 cumulatively, if you combine those members' voting rights, you'll find that they are controlling 750,000 out of a million. So they are the ones who can be able to approve a special resolution, not a single member. So cumulatively, if you have several members like a million and you have one share each, totaling to a million shares. So those who are controlling 750,000 shares out of a million shares. So they are controlling 75% of the voting rights. So they can be able to approve a special resolution.
Okay, thank you.
I hope I'm clear on that.
Yes, thank you.
Sawa.
I have a question too.
Yes, you can ask.
Under the special resolution, that the requirement or circumstances under which special resolution can take place. There's that question that is in the past papers last year.
Yes.
Explain 7 requirements necessary for the passing of a special resolution. So I thought for this question, for the one requirement, I think it is the 75%. So maybe if you can just highlight on the other requirements, that's one. And then
let me just have a look at the question. You said the question is in the last sitting. Let me just
September 2021 question.
Just read the question again. It says,
the question reads, explain 7 requirements necessary for the passing of a special resolution in company meetings.
Explain 7 requirements. Requirements for passing of a special resolution in a company meeting.
Exactly.
Explain 7 requirements for passing a special resolution in a company meeting. Let me just have a look at that particular question.
Okay, thank you.
Which sitting? Which sitting is that?
They're saying it's the last sitting.
Last sitting, yeah. Question 4.
September 2021.
Yeah.
Yes, September. Explain 7 requirements necessary for the passing of special resolutions in a company meeting.
It is question number?
Question number 4B.
question number 4B.
Yeah, and also if we may look at part C of it.
Sawa sawa. So explain 7 requirements necessary. Explain 7 requirements necessary for the passing of a special resolution in company meetings. Explain 7 requirements necessary for the passing of a special resolution in company meetings. Then part C, highlight 3 conditions which a company that is giving a notice of a general meeting through the company's website is required to comply with. So the requirements that a company is giving a notice through the company website is required to comply with. So we can start with that part C. So part C, if the notice is to be given through the company website, you're saying?
Read the question for that part C.
So 7 requirements necessary for the passing of a special resolution. So number 1, so you can say, so the meeting should be convened by the proper authority. Then number 2, the notice convening the meeting. The notice convening the meeting. So this part B, the notice convening the notice convening the meeting. The notice convening the meeting should indicate. The notice convening the meeting should indicate that a special resolution will be passed at the meeting, will be passed at the meeting, i.e., so here you can put i.e., the board of directors, Then number 2, the notice convening the meeting. So in that notice that will convene that meeting to pass as a special resolution, it will clearly be indicated that they'll be able to pass a special resolution, Then number 3, the matters that can be discussed, or you can simply say the matters that can be approved, by the special resolution, include the following. So you can mention those ones we've just indicated, include the following. So you can use dashes. You can say, for example, change of name of the company, change of name of the company, change of name of the company. You can talk about change of articles of association, and memorandum of association, change of articles of association and memorandum of association. You can mention another one, let's say, for example, mergers and acquisitions, mergers and acquisitions, mergers and acquisitions. You can talk about liquidation of the company or winding up of the company, liquidation of the company or winding up of the company. Then you can be able to talk about number 4, the resolution should be approved, by members holding at least 75% of the voting rights of the company, and have a right to attend such kind of a meeting, So you've said the meeting should be convened by the proper authority to pass the special resolution. So the meeting that is passing that particular special resolution should actually be convened by the proper authority. Then the notice convening the meeting should indicate that a special resolution will be passed or basically approved at the meeting. Then the matters to be approved.
Excuse me, Molly.
Yes.
Are you answering part B or part C?
It's part B.
Okay.
Part B. Then number 3, the matters that can be approved by the special resolution include, for example, the following. So we've indicated. Then we are saying that particular resolution should actually be approved by at least 75% of the voting rights or members holding the voting rights. So at least 75% of the voting rights of the company, members holding by at least members holding, approved by members holding at least 75% of the voting rights of the company and have a right to attend such kind of a meeting,
Mwalimu, can you also talk about the minority, the 15% not petitioning the resolution?
So the 15% not petitioning the resolution. So maybe what you can say, so maybe number 5, you can say so maybe what you can be able to say, if it is a class meeting, so you should clearly indicate if it is a class meeting, if it is a class meeting, to vary the rights of members, if it is a class meeting to vary the rights of members of a class of shares, class of shares, the resolution should be approved. It should be approved by at least members holding 75% of the voting rights in the class of shares, the voting rights, although minority, I don't know if you've been able to write this one. Although minority, you can say although minority members holding at least, although minority members holding at least 15% of the voting rights, can petition the court object to the variation, object to the variation. Then
was risky. She made the deception, lunging in at least one boot.
There's someone making noise. You can mute yourself. You can just mute yourself. I think it's Simon. So maybe the other points we'll be able to check. So I'll check in the Companies Act. And I think I'll be able to inform you more points. So maybe that can actually be able to score up to 7 marks because the question requires 7 of them. So maybe I'll check in the Companies Act of 2015 and I'll be able to inform you about the other points about a special resolution, So I think I'll check and I'll be able to let you know. So I'll check in the Companies Act of 2015. What are the other requirements with regard to a special resolution? Alternatively, in your free time, you can actually also be able to check before, maybe you can check before me, I check. So you can check the Companies Act, but I'll still check and actually be able to provide the other requirements with regard to special resolutions. Then the other question is talking about if the notice is basically, so the question is saying talking about, so highlight 3 conditions which the company that is giving a notice of a general meeting, through a company website is required to comply with, So maybe we can be able to provide the answer
kindly repeat the question?
You're saying? I can't get you clearly.
Repeat the question. You have said
the
conditions.
question. Let me just
yes.
Maybe I can share on the screen. So the question is here. It is question number 4C. Highlight 3 conditions which a company that is giving notice of a general meeting through a company website is required to comply with. Is required to comply with. Is required to comply with.
Okay, thank you.
So the first one, so maybe you can write. So you can say the notice should be of at least, the notice should be of at least 21 days as per the requirements, as per the Companies Act, as per the statutes, or the Companies Act, as per the statutes or the Companies Act. The number 2, the notice should clearly indicate, the notice should clearly indicate the date, time, place and agenda of the general meeting, So the notice should clearly indicate the date, time, place and agenda of the general meeting, Then the notice should be signed by an authorized director or the company secretary So you're saying the notice should be of at least 21 days as per the statute or the requirements of the Companies Act. The notice should clearly indicate the date, time, place, and agenda of the general meeting. The notice should be signed by an authorized director or the company secretary or the company secretary. The next one, the notice, there's something I forgot to tell you about. The notice should be accompanied. The notice should be accompanied by a proxy form, for shareholders, a proxy form for shareholders not able to attend the general meeting to appoint a representative or proxy. So a proxy is a person who can be able to represent a member of a company in case you are not actually able to attend the meeting. So what normally happens is that when the company is giving out a notice for a meeting, they'll be able to give what we call a proxy form accompanied by that notice. such that you as a member of the company, you will be able to fill out that proxy form and clearly indicate maybe you won't be able to attend the meeting. Then before the meeting actually is held, quite early in advance, you can present the proxy form to the company that this is the person who will be able to attend, and actually I'll be able to guide him on how he'll be able to vote or approve on the matters concerning the company. So if you're not actually able to attend, you can be able to maybe fill out that particular proxy form. So maybe they can use a search engine, or basically they can put there something that can be downloaded, like a form that can be filled out, or maybe they could allow you basically just to fill it online, and actually be able to send it to the company, so that the company can actually be able to get the information instantly and know who will basically be able to represent you as a member of the company, So that is basically what the company should actually be able to ensure in case they are basically giving out that particular notice. So these are the requirements of any notice convening a meeting in whatever way, in whatever form that the company is using to be able to convene the meeting, whether it is in a newspaper, whether it is maybe they are doing a radio announcement. So they should ensure that they are doing those radio announcements within a time limit of 21 days before the meeting. Then the notice, of course, anywhere, even it is in a newspaper, it will clearly indicate where will be when will the meeting be held, what will be the time, and what is the place. Is the meeting going to be held at KICC? So what will be the agenda at the meeting? The notice should actually be signed, or basically they clearly indicate who is basically convening or has been given the right to be able to undersign or ensure that he signs on behalf of the company to ensure the notice is seen as being authentic. So if you look at the website, you can see the notice is actually very authentic. They'll be able to accompany the notice with a proxy form. So that proxy form basically will give you a right as a member of the company to be able to appoint a proxy or a representative to represent you in case you are not actually able to attend the meeting. You are not actually able to attend the meeting. You are not actually able to attend the meeting. Yes, you have a question. You can ask.
Yes. When you said for Nini, you said 25%.
You are not audible. Just be audible.
The 15% can petition for objection for verification of Nini of shares, Indio.
Variation of class rights. Can petition for variation of class rights, yes.
So is that specifically for variation of class rights alone, or any other resolution, okay, hold meeting, and any other special resolution, if more than 25%, more than 15% of the minority shareholders can petition to object against any other resolution apart from class rights?
No, only class rights.
Okay, thank you.
Only variation of class rights is when under the Companies Act it has been allowed that those minority members in that class of shares can basically object. But for example, for other matters which are not concerning class rights, for example, share capital reduction, so long as it has been approved by the majority, there is no window open for the minority to go to the court to object to the share capital reduction. There is no window for such. But only under class rights, so under variation of class rights, the members in that class of shares who are actually the minority, they're the ones who can actually be able to object. So it is actually only under variation of class rights. That's basically where now the minority have been given a right, at least 15%. So those who hold at least 15% can actually be able to object, by petitioning, can actually be able to object by petitioning. So I think we can proceed unless there's another question you've come across. So for those requirements under special resolution, I think I'll check the Companies Act and see if there are any other requirements, any other requirements with regard to special resolutions, with regard to special resolutions, then I think I'll be able to communicate. So I think we can start the next topic. Of directors. We can start the next topic of directors. So directors. So what you need to know under this topic is who is a director of a company, who is a director of a company, then appointments of directors, then qualifications for appointments, then disqualification from office as a director, disqualification from office as a director, then duties of a director, the other key thing to be able to know under this topic. Another thing is remuneration of a director, Then there's what we call compensation for loss of office. What happens in case a director is actually lost office unfairly? Compensation for loss of office, Then the last thing we'll be able to learn about is what we call insider dealing, or what we call insider trading, So when you talk about a director of a company, a director of a company is any person who can be seen to oversee the overall management, or basically the overall management of the company, or oversee the overall operations of the company. Such kind of a person will basically be termed as being a director of a company. So under the statute or under the Companies Act, a director of a company is any person who has been given the mandate or has been mandated to oversee the overall management or the overall functions of the company or the overall processes of the company. Such a person will be termed as being a director of a company. So it simply means that in certain places, this person might not actually be having this particular title we are talking about, a director. But so long as this person can be seen to oversee the overall management, or basically oversee the overall processes of the company, such a person will actually be termed as being a director of a company. So maybe he can be given a different name, but so long as he's overseeing everything in the company, has been given that mandate, for example, by the owners or the shareholders of the company. And even if he doesn't have this particular title, a director, under the law or under the Companies Act, such a person is normally termed as being a director. So the title is not actually important as per the law or as per the Companies Act, so long as the person is overseeing the overall operations of the company. Then under the law or under the Companies Act or the statutes, he can be recognized as being a director of a company. Another thing to note is it doesn't matter whether it is actually in an acting capacity all those actions by the director, the company can actually be held responsible or culpable. So in such a case, the director will act as an agent of the company while the company is the principal. Even if it is actually in an acting capacity, those actions that were taken by the director will basically be presumed that they were being carried out while him or her, he was actually a director of the company. So it doesn't matter whether it's actually in an acting capacity or actually not, so long as basically you are in that office and you are actually overseeing the overall operations, then under the law, you'll actually be recognized as being a director of a company. That is what we mean by a director. So we've said the key point to note here, the title is not important. Under the Companies Act, a director is defined as any person who is actually able to oversee the overall management or the overall processes of the company, overall management or the overall process of the company. Such a person under the Companies Act or under the statute will be termed as being a director, will be termed as being a director. That is what we mean by a director. So as you can be able to realize, the company won't just function. So there must be some managers there, those top guys. So they'll be termed as being directors. They should be there to oversee the functions or management of the company. So we have the appointment of directors, the appointment of directors. So you as a person, you can be able to find that you've become a director in a company under several circumstances. For example, in this case, you could actually be a first-time director. You can actually be a first-time director. You can actually be a subsequent director, subsequent director. You can actually be an, you can be able to say an associate director, an associate director. You can be an alternate director. You can be an alternate director. You can be maybe become a managing director. You can become a managing director in a company, a managing director. In other places, this person will be known as the chief executive officer, the chief executive officer. These are basically you can find yourself being a director of a company. What we mean by first-time director, for example, when we are looking at the topic of formation of companies, we say that the promoter of the company or the person forming the company will simply propose who will be the first-time directors of the company. Who will be the first-time directors of the company? Who will be the first-time directors of the company? So in such a case, on formation of the company, you can find out that you've basically been proposed to be the first-time director of the company. In this case, it simply means that you're actually appointed, like, for example, by the promoter of the company on formation of the company. Alternatively, you can become what we call a subsequent director. So these subsequent directors will actually be appointed at now that AGM we were talking about. Remember, on formation, there is no AGM that has actually happened. So it simply means that the promoter has to propose, because when you're registering the company, for example, if it is a private company, it is mandatory under the law, the company should have at least one director. If it is a public company, it should have at least 2 directors. So where will you find these directors? Yet the company has not actually even existed for a year to basically have an AGM. You must actually be able to propose as the promoter of the company. So in this case, they'll propose Kezia as the first-time director. So that's how Kezia will become a director of a company. Then subsequently, what will happen in the company, now the company is actually in existence, has been formed. Subsequently, they'll hold an AGM and of course decide that maybe Kezia can continue to serve as a director, or they can remove Kezia from actually being the director of the company. So what normally happens, or what we normally say, the persons who have the rightful mandate to appoint a director in a company are the members of the company. But of course, you can see under that particular circumstance on formation, the AGM has not actually been held. So it simply means that this particular director can actually be appointed by the promoter. So the members will take their rightful mandates as per the Companies Act to appoint directors at the first AGM, or they'll appoint what we call subsequent directors of the company, subsequent directors of the company. So subsequently, basically, it simply means that now at each and every AGM, the members have to either appoint or maybe remove some directors, or maybe reappoint other directors on another term to be able to continue to serve as directors of the company. Then we have an associate director. An associate director is simply a director of the company who doesn't actually engage in full-time service with regard to the operations of the company or management of the company. So he's not actually always there to basically oversee what is actually happening in the company. But for him, it is simply to represent the interests of certain parties on the board of directors. So in this case, if we choose, for example, a company like Safaricom, Safaricom has key investors or key stakeholders. The government of Kenya has an interest in Safaricom. Vodacom as a company has an interest in Safaricom. Maybe Vodafone also has an interest in Safaricom. So you might find that Vodafone has actually been able to appoint a director to serve on the board of directors of Safaricom. This guy is basically just representing the interest of Vodafone as a company. So he will be termed as being an associate director. So it is simply a director who basically represents the interest of certain parties on the board of directors. Such a director does not actually basically engage himself in the full-time management of the company. So he basically maybe just attends the board of directors meetings from time to time. So he'll actually be known as an associate director. That director appointed by Vodafone to sit on the board of directors of Safaricom will basically be termed as being an associate director. So you can be able to find yourself being a director in a company as an associate director, and that is what we mean by an associate director. We can have an alternate director. Something can actually happen, something can actually be able to happen, something can happen. So repeat the meaning of a first-time director. A first-time director is that director who will actually be appointed by the promoters of the company. At this particular point, when I mention a promoter, you should actually be able to understand who is a promoter. Under formation of companies, we indicated, or basically we clearly said, a promoter of a company is someone who basically undertakes to form a company and set it up as a going concern or to exist for the foreseeable future. Formation of a company is a process. A company does not just come into existence from anywhere. It is a process. That process is normally undertaken by the promoter. One of the duties of a promoter is to propose who will be the first-time directors of the company. So those first-time directors of the company are the ones who can be appointed by the promoters of the company on formation. Because most obviously, when you are going to register your company, the register of companies basically require, for example, if it is a private company, you have at least one director. If it is a public company, you have at least 2 directors. Where will you get these directors? Yet you've not actually even held the first AGM. So you can just propose as the promoter that these persons are the ones who will basically be the directors of the company. So the first-time directors, so we are saying in this case, for D, you can actually be able to become a first-time director by being proposed by the promoter of the company. Alternate director. Who is an alternate director? An alternate director, you might find that sometime maybe there's a director who is serving on the board of directors who is not actually able maybe to even attend the board of directors meetings, maybe due to certain circumstances, maybe illness, or maybe he's basically out of the country to engage in other matters. So it simply means that he's not actually able basically to attend the board of directors meetings. He can actually be able to appoint someone to be able to represent him or to sit in for him while he's actually away, or maybe on medical leave, or maybe due to illness or due to other factors, he's not actually able to come for the board of directors meetings. So it simply means that he can actually appoint someone to represent him on the board of directors. That particular director will be termed as being an alternate director. Managing director or chief executive officer. So this one mostly will actually be appointed by the board of directors. So they'll be able to choose someone who has expertise or knowledge on how he can actually be able to manage the affairs of the company. This one is the one mostly who will be engaged in the full-time management of the company. So that's why in most company structures, you'll see at the top, there's the board of directors, then there's a link here, an MD, then down here, you'll find, for example, financial managers, human resource managers, marketing managers. So you'll basically just sit under the managing director. So he'll simply act as a link between the company's operations and, of course, the board of directors. So he'll be able to sit on the board of directors and, of course, maybe get the strategies the board is basically coming up for the company to be implemented. Then he's basically sent out in the company now to implement the strategies as the managing director. So he'll still basically sit on the board of directors as one of the directors of the company and act as a link between the board of directors and the company itself. In other places, he's not known as a managing director. They'll call him a chief executive officer. So this is basically how you can become or find yourself being a director in a company. Those are some of the ways of how you can become a director in a company, So appointment of directors, as we've said, that's how it can happen. Maybe you can be a first-time director. You are actually appointed by the promoters. You can be a subsequent director. Maybe you're appointed by the members at the annual general meeting. You can be an associate director. You can actually basically be an alternate director or maybe be a managing director. But of course, the key point here, the teacher is actually stressing, is that the persons who basically have the rightful mandates to appoint a director in a company are normally the members of the company, because members are putting their directors to be able to manage the company on their behalf, because they are not there always as investors or owners of the company to run their affairs. So therefore, they'll be able to appoint persons to manage the company on their behalf. So simply, they'll be able to appoint directors to oversee the functions or basically operations of the company. So members of the company are the ones who basically have the rightful mandate to be able to appoint a director in a company. That's why even under meetings, we've said in the annual general meeting, there'll basically be the happening of whereby we are having appointment, reappointment, or removal of directors at an annual general meeting, So what are the qualifications? What are the qualifications before you can become a director of a company? What are the qualifications? There are normally just 3 key qualifications. Number 1, you must have attained the age of majority, that is 18 years. Number 2, basically, you must have taken up what we call qualification shares. Then number 3, you must have not basically been declared to be bankrupt. So bankrupt means basically you're not actually able to meet your obligations. And of course, your creditors have actually been able to go to the courts. So your assets basically have maybe been taken up by a receiver who basically has seized them on behalf of your creditors. So you have to pay for all your liabilities. So if the court declares you to be bankrupt, it simply means that you are not qualified to be appointed to be a director in any company. Then of course, also if you've not attained the age of 18 years, you won't be appointed. So you're saying the qualifications, you must have attained the age of 18 years. Number 2, you must have not been declared to be bankrupt by a court of law. Then number 3, you must have taken up what we call qualification shares. What are qualification shares? Qualification shares, this is what we mean by qualification shares. What we mean by this, we are saying that when Kezia basically becomes a director, either as a first-time director or basically as a subsequent director, Kezia must actually be able to take up some shares in the company as per the requirements, for example, under the model articles. So it simply means that when you become a director of a company, it is a requirement you take up some shares in the company. So we say that financial prudence requires that when you become a director in a company, you take up some shares or you become a part owner. Because in this case, if you are making decisions, basically you are making them on behalf of all the shareholders of the company. So for you to make prudent decisions, then you must be a part owner. You must be one among those ones you are making decisions on your behalf. So when you become a part owner, basically you are likely to make prudent decisions, because in this case, you'll just be like the other shareholders. So you must actually be able to take up what we call qualification shares, which should actually be taken up within a period of 60 days, or sometimes we say 2 months, 60 days, or sometimes we say 2 months. So kindly repeat the meaning of first-time directors. So I think I've repeated. Could you repeat on the meaning of qualification shares? Could you repeat on the meaning of qualification shares? Qualification shares are shares that must be taken up by a director, basically when he's actually appointed as a director of a company. So a director of a company will be required to take up some shares in the company. He must actually become like a part owner of the company. So those shares he takes up will be known as qualification shares. So they are normally shares taken up by a person appointed as a director of a company. Then what you need to note about that, it is that under the model articles in the Companies Act, it is a requirement these shares should be taken up within a period of 60 days or 2 months. So lazima uzichukue within zile umepatiwa, lazima uchukue within a period of 60 days. Maybe you can pay for them or acquire them within a period of 60 days. So those shares you take up, you as Kezia, when you become a director in a company, so this company is known as Safaricom, when you become a director there, they'll require you to take up some shares there. So once you take up the shares, it simply means that they'll be termed as being qualification shares. So they should be taken up within a period of 60 days, within a period of 60 days. So that's what we mean by qualification shares. So if you look at those particular requirements, so education is not actually a major requirement for you to be appointed a director, but of course, some directors, basically they require some form of expertise or maybe some experience you've served elsewhere before you can actually be appointed to be such kind of a director, especially this one, managing director. So the managing director of Safaricom, he has worked for very key companies across the world. So they look for expertise sometime before they can actually appoint you to become maybe a certain director, because in this case, they just want you to bring in expertise on the board of directors. But of course, education as per the Companies Act, it is not a major requirement for you to be appointed as a director of a company. So even when you are seeking for registration of a company, if you want to become a director, they won't ask you that what is your level of education. It is not important for you to become a director in a company. So they are just those three. So you've said you've taken up the qualification shares, you've actually been able to attain the age of the majority, that is 18 years. So then you've not been declared to be bankrupt. So because you'd basically now be a great person or a good person to qualify as being a director of a company, as being a director of a company, as being a director of a company. So I would wish to end there the class for today. So next time we'll actually be able to wind up on this particular topic of directors. But of course, we look at a few questions here and there, and see how it is actually tested in the exam, so that we can actually be able to see how far we can actually be able to go. So after this topic, we'll start the topic of company secretary. Company secretary is actually very short. Maybe probably in the next class, we'll actually wind up with it. It's not that long. It is not that long. So the next topics are not quite long, like the first ones there. So that's what I was telling you. If you miss a class, probably you're likely to miss like a whole topic. So you should actually be very consistent from right now up to the exam time. So if you miss a class, probably you'll miss like the whole topic, because the next topics are not that wide, but of course they have key points you need to be able to note, because you might find that the topic is not that wide, but there are small areas you need to actually be able to understand very, very properly. So for example, they could ask, what is the requirement with regard to qualification shares of a director of a company? So basically, you need to define what are qualification shares. Then, of course, clearly state that they should be taken up within a period of 60 days as per the requirements of the model articles under the company. So you might find they just test such a small area, and of course, they put there, like, for example, 3 marks. So if you have no clue what is qualification shares, then basically you might actually lose those particular marks, even though if the topic is not actually that wide. So even though if the topic is not that wide. So unless there's a question, you can ask a question at this particular point, because me, I would wish I ended the class there. Yes.
I have a request.
You have a request?
Yes, I have a request. Could you send the videos for the previous 2 classes? I missed them.
For the previous 2 classes? Yes, I think I recorded them. I recorded them, but I recorded them. So what I'll do, I'll tell the guy who normally compiles the videos to share with me. Then I can be able, I'll push for him to be able to share with me. Then I think I'll share. I think I'll be able to share. Probably let me see this weekend if he'll be able to provide me with the videos, because most of the time I'm not in the studio, so just once in a while. So, but I'll talk to him to give me the links, then I can assist maybe those ones who are not actually able to attend. So what you do, you remind me, you can just inbox, you remind me, because I might forget. Just remind me so that also I push for the video to be shared with me, then I can share the link with you.
Okay, thank you.
Mwalimu, even this one, I joined in a bit late.
You joined in, this is Winnie, you joined in late?
Yes.
So I think this one also will be, the good thing I've recorded from the start. So I think I'll also ask for the link to be shared with me, then I can share.
All right, thank you. Share.
Edna has a question. So I don't know if there's any other question or any other concern. I think we can end there the class. We'll meet next week on Wednesday. We'll meet next week on Wednesday. As I told you, the target is to finish this syllabus before the end of this month. By end of this month, then like 2 weeks of December, we'll just do revision and prepare for the exam. So I wish you a good night and we'll meet next time.
Thank you.
Thank you. Good night, sir.